All right, let's unpack this. Today, we are diving into something that seems, incredibly routine traffic law, but it holds one of the most powerful legal surprises in civil litigation, actually. We're deep diving into a specific North Carolina statute, Section 20158, focusing on stop signs and signals.
Right. And what's immediately fascinating for you to understand is that in many states, if you say, run a stop sign and cause a wreck, well, you're automatically considered negligent in a civil suit.
Okay.
It's a doctrine called negligence per se, which is really just a fancy way of saying, if you break that specific safety rule, boom, you're automatically civilly liable. No real questions asked about whether you were trying to be careful or not. But North Carolina's legislature, they deliberately wrote a specific section, Section D, into this statute to prevent that, to stop that automatic fault finding.
So we're analyzing why, even if you clearly, undeniably broke the traffic rule, why you might not be automatically on the hook in a personal injury lawsuit.
Exactly.
That's the core counterintuitive tension we're tackling today, then.
Precisely. We'll start with the strict rules of the road, like where and how you must physically stop your car. And then we'll move straight into a really structured breakdown of that key part, Section D, which, as I said, acts like the legislature's firewall against finding automatic fault.
Okay, sounds good. Let's start with the basics, then. If I see a stop sign at just a standard intersection, what are my two fundamental legal obligations under the statute? Let's say under subsection B1.
Okay, so two main things are required there. First, the driver must execute a complete stop, full stop, in obedience to the sign.
Right.
And second, you have to yield the right-of-way. That means yielding to any vehicles already on the main road, the through highway you're approaching.
Okay.
Now, there is a small exception. If you pull up and there are stop signs at 3 or more entrances to that intersection, well, once you stop, you can then proceed, but with caution.
Got it. Now, the law isn't just about stopping, right? It's picky about where you stop. I want to test the technicality here. Based on subsection B5, what's the strict, sort of hierarchical order of the 3 places a driver has to stop when required?
Ah, yes, the location hierarchy. This rule applies whenever any sign or signal tells you to stop. You have to hit the brakes at the first location on this list that's actually present. It's very specific.
Okay, what's number 1?
Number 1, the highest priority, is an appropriately marked stop line. If you see that white line, you stop there.
And if there's no line?
Then number 2, you stop before entering a marked crosswalk.
Okay, no line, no crosswalk. What's the last resort?
Then number 3, you must stop before actually entering the intersection itself. And specifically, at the point nearest the intersecting street where you, the driver, actually have a view of oncoming traffic.
That makes sense. You need to be able to see.
Exactly.
Now, what happens when when the signals break down? Say a power outage knocks out the traffic lights completely. What rule applies then?
That's a great question, and the law actually anticipates this exact scenario. Subsection B6 covers it. Basically, vehicles have to approach and go through that intersection as though it's controlled by a stop sign on all approaches.
Ah, so it becomes an always stop.
Precisely, an always stop situation, unless, of course, you have a police officer or maybe a crossing guard there directing traffic. Then you follow their instructions.
Okay, that clarifies the rules of the road part. Now let's shift to the courtroom implications. This is where Section D comes in, right?
Yes, the big one.
Let's really dissect the legislative thinking behind this statute's most important civil liability rule. Let's use that structured approach you mentioned. First, set the scene. What are the key statutory facts we need to analyze regarding civil liability?
Okay, facts. We're focusing on the exact wording of Section 20158 TSAC. The key text states, and I'll quote a bit here, "No failure to stop is required by the provisions of this section shall be considered negligence or contributory negligence per se in any action at law for injury to person or property."
Okay, so that's the prohibition.
Right, but then it adds that the facts about the failure may still be considered, along with other facts in the case. And contextually, this is super important because it's very different from how many other states handle this.
Right, you mentioned that earlier. So why? Why did the legislature do this? If a driver clearly blows through a stop sign and causes a serious accident, why protect them from that automatic fault finding? Seems like it makes it harder for the injured person. What's the core legal issue this section is addressing?
The precise legal issue is, did the North Carolina legislature intend for a simple violation of its traffic stopping rules to automatically establish negligence in a civil lawsuit? In other words, should breaking the traffic rule bypass the need for the injured party to prove the driver was actually careless under traditional common law principles?
So it's about preserving that common law analysis.
Exactly. Reflect a major policy choice. They seemingly prioritize letting a jury make a nuanced decision about carelessness based on all the facts, rather than allowing for a potentially faster, more efficient lawsuit based purely on the traffic violation.
Okay, let's break down the rule itself from Section D. Can you state the full black letter rule and break it down into its testable elements, its core functions?
Sure. The rule is Section 2158D. It governs how a violation affects civil liability. It essentially has two crucial coexisting elements. First, there's the prohibition. It states that failure to stop as required shall not be considered negligence or contributory negligence per se. That's element one. Second, there's the admissibility. It states the facts relating to that failure may be considered with the other facts in determining if a party was negligent. That's element two.
Thank you. Now for the court's elemental analysis. Well, in this case, the legislature's analysis built into the statute. Let's walk through it. How does the statute enforce the first element, the prohibition of negligence per se?
Okay, let's do a mini IRX for this element. The sub-issue here is really about the standard of proof in a civil case. The sub-rule, stated plainly in the statute, is that negligence per se is removed as an option for this violation. Applying that, it means that the plaintiff, the injured party, cannot win their negligence claim just by showing the defendant got a ticket for running the stop sign. That's insufficient on its own to prove the breach of duty element of negligence. So the conclusion for this element is that the statute mandates a full common law negligence analysis. It preserves the jury's role in deciding if the driver's actions were actually careless under the circumstances.
Understood. So just getting the ticket isn't enough to win the civil case, but you mentioned that the facts can still come in. So what about the second element, the admissibility of facts? How does that work?
All right, let's analyze that element. The sub-issue here is the evidentiary weight of the violation. While it's not automatic fault, what does the violation mean in court? The sub-rule, again from the statute, is that the facts surrounding the failure are admissible. So applying that, evidence like, say, the driver ran the red light 5 seconds after a change, or they stopped way past the crosswalk, or maybe they didn't stop at all those details can be presented to the jury. And the conclusion for this element is that these facts serve as powerful evidence suggesting the driver failed to exercise the due care expected of a reasonable person under the circumstances. That's the core standard for common law negligence. So the violation itself becomes strong proof pointing towards negligence, even if it's not negligence itself.
Okay, putting those two elements together then, the prohibition of automatic fault, but the allowance of the facts as strong evidence, what's the final conclusion regarding the overall effect on civil liability when someone violates the stop sign statute?
The final conclusion is that Section 2158 creates a system where a traffic violation is treated as significant evidence of negligence, but not as a conclusive automatic finding of negligence. It forces the lawsuit to proceed under the traditional common law framework. The plaintiff still has to prove the defendant was careless, but the fact they violated the statute makes that argument much, much stronger. It shifts the practical burden, you could say, even if not the legal standard of proof itself.
That clarity on Section D is really crucial. Let's use one of those visceral hypotheticals you mentioned to really lock in the where to stop rule from earlier, subsection B5, and connect it to Section D. Imagine a driver in a massive, torrential thunderstorm. Visibility is awful. They stop exactly at the stop line, just like they're supposed to, element one.
Yeah.
But because of the blinding rain and maybe some fog, they can't see a thing. So they cautiously inch forward, maybe 15 feet past the line, creeping into the intersection, hoping to get a better view before they proceed. And by doing that, they technically violate element 3, stopping where they have a view, and unfortunately, they cause an accident.
Yeah, that's a tough spot we've probably all been in or tempted to be in, where you feel blind at the line and you just want to creep up.
Exactly. So if that driver gets sued by the person they hit, what does Section D mean for their defense? We know the violation isn't negligence per se, but what's the practical reality for their lawyer?
Well, the lawyer can breathe a small sigh of relief because Section D means they don't lose automatically just because of the technical violation of B5. They have a defense against that immediate finding of fault. However, the facts creeping 15 feet into an active intersection during blinding rain because you couldn't see those facts are highly admissible under the second part of Section D. And you have to ask, under the common law standard of due care, would a reasonable person do that? A jury is very likely going to look at those facts and conclude that creeping forward was a breach of the duty of due care. It was careless driving under the circumstances. So the legislature took away the automatic legal label of negligence per se, but they absolutely did not remove the powerful evidentiary weight of driving poorly or violating the specific stopping rules. It makes the defense very difficult, even without being automatic.
That really drives home the point. Okay, let's pivot slightly to another really common scenario. Right turn on red. What specific detailed duties does the statute impose on a driver making that right turn against a steady red light? Let's look at subsection B2.
Right, turn on red. This rule is actually incredibly detailed, and it shows a really specific legislative focus on pedestrian safety. So after coming to a complete stop, the driver has two distinct yielding duties, two elements, really. First, the obvious one. The vehicle has to yield the right-of-way to other traffic and pedestrians who are already lawfully using the intersection.
Okay, standard yielding. What's the second duty?
The second one is more subtle and really important. The vehicle must also yield to pedestrians who are moving towards the intersection, who are in reasonably close proximity, and who are preparing to cross the street in front of the traffic that is required to stop, which is the turning vehicle.
Wow, so you have to yield not just to pedestrians in the crosswalk, but those who are about to enter it if they're close. That's quite anticipatory.
It is. It shows a high degree of care required towards pedestrians in that specific situation.
Does the statute specify a particular penalty just for failing to yield to that second group, the approaching pedestrians?
Yes, it does. Yeah. The legislature singled this out. Failure to yield to a pedestrian under this specific subdivision. The approaching pedestrian rule is designated as an infraction, and it even comes with a specified penalty range. Not less than $100 and not more than $500.
Right.
So they put teeth into that specific pedestrian protection.
That's fascinating detail. Okay, this has been an incredibly detailed look at the statute, its intent, and this whole civil fault carve-out. For our listener, the learner, trying to make sense of this for, say, an exam or just understanding liability, what's the step-by-step diagnostic checklist we can synthesize from this deep dive? How should they approach analyzing a traffic violation in this jurisdiction?
Okay, yeah, let's build an actionable checklist. If you encounter a problem involving a vehicle control sign violation under this North Carolina statute, here's a rigorous three-step approach. Step 1. Define the specific breach. Don't just say they ran the stop sign. Use the statute's subsections we discussed, like A and B, to precisely define which specific duty was breached. Was it the failure to stop and yield at all? Was it stopping in the wrong location according to the B5 hierarchy? Was it the failure to yield on a right-on red to that approaching pedestrian under B2? Or maybe the power outage protocol under B6? Be precise.
Okay, nail down the exact rule broken first. What's step 2?
Step 2. Determine the legal effect criminal infraction versus civil. Ask yourself what the question is about. Is it about a ticket, a fine, a criminal penalty? If yes, then the statute might apply directly, like that specific $100 or $500 infraction fine for not yielding to the approaching pedestrian we just talked about.
Got it. Check if it's about the ticket itself. Then step 3.
Step 3. Analyze civil liability using Section D. This is key. If the question is about civil liability, like, is the driver negligent in a lawsuit? Your first thought, your first statement must be, do not use the doctrine of negligence per se. Explicitly state that Section D prohibits it for this statute.
Okay, rule out negligence per se immediately. Then what?
Then you pivot. You analyze the situation using standard common law negligence principles, duty, breach, causation, damages. But critically, you treat the facts of the statutory violation you identified in Step 1 as strong, admissible evidence that the driver breached their duty of due care. So the breach of duty still needs to be proven under the reasonable person standard, but the fact that they violated the specific traffic safety statute becomes your primary, often most persuasive piece of evidence to prove that breach.
So the violation isn't the conclusion, but it's Exhibit A for proving carelessness.
Exactly. That's the practical effect of Section D.
We've seen today that in law, even something seemingly black and white, like a stoppy sign mandate, doesn't automatically dictate civil fault. At least not here, because the legislature deliberately built this policy firewall.
That distinction, that policy choice between making a regulatory infraction automatic civil fault versus just making it strong evidence, it's a massive legislative decision. It fundamentally shapes how these common accidents are handled in the legal system.
For you, the listener, we really hope this deep dive provides not just the rules themselves, but that crucial structural understanding of how these rules are actually applied in a courtroom, forcing that element-by-element thinking and consideration of legislative policy.
And we'll leave you with this final provocative thought to mull over. Imagine if the North Carolina legislature had not included Section D. If they had let the standard negligence per se rule apply, like in many other states, how do you think that would change things overnight? Think about insurance rates, settlement negotiations, the speed of lawsuits. Would drivers actually become more careful? Or would lawsuits just become simpler, faster, and maybe more numerous? Who wins and who loses in that scenario?
Definitely something to think about. Until next time, keep digging deep.